Tonight with Asena Ömür and Sabrin Albayrak from Tevetoğlu Legal, we will do our best to provide you some key points from our research. I will be talking on legal frameworks for tokens and coins, legal status of real-world asset tokenization, legal frameworks for decentralized autonomous organizations, and taxation of crypto assets in general. I'm excited to delve into the dynamic and complex world of crypto assets, specifically focusing on its legal aspects. This is a field that merges cutting-edge technology with legal principles, creating a landscape that is as fascinating as it is challenging. Firstly, let's understand the basics. Crypto assets can be broadly classified into two categories: coins and tokens. Coins, like Bitcoin and Ethereum, operate on their own blockchain and are generally used as digital currencies. Tokens, however, represent assets or utilities and exist on pre-existing blockchains. Among these, non-fungible tokens have gained notable attention, representing unique digital items using blockchain technology. As an overview, we can say that since the main function and feature of the Bitcoin is its usage as a means of payment, brings it closer to the banking law and other relevant applicable laws. On the other hand, possibly adhered regulation regarding altcoins shall be closely examined and determined according to its functions and nature. The more they are close to becoming a means of exchange, the possibility of being subject to the banking law respectively increases. On the other hand, if an altcoin has some features that are eligible to fall into the scope of capital market instruments and also rules, then it's more likely for them to be subject to capital markets law. The legal treatment of these assets varies significantly across jurisdictions. For example, in the United States, the Securities and Exchange Commission, SEC, plays a pivotal role. They scrutinize tokens to determine if they qualify as a security, which has wide-ranging applications from regulatory compliance to investor protection and etc. If a crypto asset is deemed a security, the issuer of the token or coin, general crypto asset, must register with the SEC. The SEC has interpreted the Howey test to apply to almost all crypto assets currently available. The Howey test, and it's a Supreme Court case, is a key tool in this analysis, assessing factors like is there investment intent and are there any expectations of profits. Basically, the Supreme Court stipulated the Howey test, defining an investment contract as a scheme involving the investment of money in a common enterprise with profits to come solely from the efforts of others. Since Bitcoin and its blockchain do not constitute a common enterprise, the value of Bitcoin do not depend on the performance of third parties. The simple fact that Bitcoin is not issued or controlled by a group or entity, and Bitcoin is generally regarded as a commodity by the CTFC, another US authority, Bitcoin do not meet criteria set forth by the Howey test. Therefore, we cannot consider Bitcoin as a security. It's not a security in terms of US law. Furthermore, the SEC has faced criticism for applying an outdated case to new technological innovations such as crypto assets and blockchain technology. Many critics and scholars argued that using a case from 1946, meaning that Howey test, for the crypto asset markets, and crypto asset markets emerged only in around 2008, goes against the Administrative Procedure Act. The SEC also has been accused of providing unclear guidance and favoring early tokens like Ether while rejecting new market participants. In contrast, European Union approaches crypto assets regulations with a more focus on consumer protection and financial stability. Markets in crypto assets regulation, I will call it MiCA shortly, is the leading regulation in this regard, and we will further examine it later. So I will just provide the overview for just now. The European Union's fifth anti-money laundering directive is a notable regulation, and it plays a pivotal role in enhancing transparency to prevent fraud and money laundering. In conclusion, the legal landscape for crypto asset is continually developing. As we embrace these technologies, staying informed about these changes is not just beneficial, but also necessary. The future of finance is being rewritten one token at a time. Now I will move on to our next topic, real-world asset tokenization. Sabrin, could you please? Thank you. As you all know, blockchain technology allows for the tokenization of traditional assets, meaning that tokens can be used to represent various types of instruments, such as stocks, bonds, real estate, consumer loans, even arts, and etc. Basically, anything can be tokenized. By tokenizing these assets, we gain the ability to seamlessly incorporate them into the blockchain, unveiling a vast array of opportunities for innovative applications. In some cases, blockchains need to connect with non-blockchain systems and applications to exchange information. Oracles act as a bridge between blockchains and other information sources. These oracles monitor and verify real-world information, such as events and identities that smart contracts initially don't have access to. So basically, oracles provide necessary information to smart contracts. Oracles provide a trusted data feed to smart contracts, allowing them to monitor relevant information and automatically execute programmed code. Oracles plays a crucial role in ensuring the reliability of smart contracts. Although oracles can accurately analyze real-world events, there are some potential threats. If the data source outside of the blockchain is tampered with or unreliable, it can lead to incorrect results, undesired results in the smart contract process. This is known as the oracle risk. To address this, a transparent, reliable data sources are needed, along with smart contracts that rely on consensus-based oracles instead of a single oracle. So there are some work that shall be carried out to improve oracle and information, the security of information that they provide. Okay, how do we determine the economic value of a real-world asset token? Yes, we can tokenize anything, but how do we decide the economic value of such token? Perhaps the most common valuation method is the net asset value metric. In this financial metric, the economic value of real-world asset token is calculated based on the economic value of the underlying and total number of issued tokens. Another approach is called income approach. The predicted income that an asset can produce is the foundation of the income approach to valuation, which is especially important for asset-backed tokens connected to income-producing assets. This involves projecting the amount of money that the asset will yield over a specific time frame. This could be the rental income from real estate, earnings from a business, or the interest or dividends from a financial asset. It can be anything that may continuously develop economic value. And perhaps most important thing we shall consider is also, are real-world asset tokens regulated? And if they are, how so? In terms of US, for the SEC to be able to take action against a crypto asset, such crypto asset has to be eligible to be regarded as a security, as I mentioned before. We just talked about this matter and explained how Howey test works. If a tokenized asset fits all elements of the Howey test, it's likely to be regarded as a security and hence subject to SEC's or other regulatory bodies' regulatory obligations, which include registration or obtaining an exception, disclosure, and etc. There are many things to consider. When a real-world asset token is considered to be a security by the SEC, then the issues offering, and even trading of such tokens is quite problematic. If a token is classified as a security, it is subject to the regulatory framework for securities, which is largely controlled by the Securities Act of United States and Securities Exchange Act. These laws and applicable rules are monitored and governed by the SEC. If a token is in fact a security, then unless they qualify for an exception, securities must be registered with the SEC. Registration entails releasing information about companies' commercial activities, financial position, management, as well as investment risks. Furthermore, the mere act of offering a token that is eligible to be considered as a security may in fact result in serious violations of relevant securities law. It will most probably considered as unregistered securities offering, which has severe penalties, both criminal and financial. On the other hand, in the European Union, there are various articles regarding tokens backed by real world assets. I'm referring to Markets in Crypto Asset Regulations, MiCA. In Article 3 of Markets in Crypto Assets, asset reference tokens are defined as a type of crypto asset that is not an electronic money token and that purports to maintain a stable value by referencing another value or right or combination thereof, including one or more official currencies. MiCA prefers the term asset reference token, and here how it regulates these tokens. MiCA foresees an authorization process, requirement for credit institutions. Only the issuer of the asset reference token can make an offer to the public or seek the admission to trading of an asset reference token. Also, they must be a legal person or an undertaking that is established within the European Union and have been authorized by a competent authority. Or they must be a credit institution that complies with relevant articles of MiCA. MiCA actually seeks to ensure that asset reference tokens are issued by trustable entities that are regulated and protecting investors. The regulation also seeks to ensure that our asset reference tokens have asset reserves and that will protect investors at all costs. Furthermore, MiCA strictly defines how a white paper regarding asset reference tokens shall be. The marketing of asset reference tokens is governed by regulations focusing on the clarity, fairness, and transparency of information in white papers and marketing communications. Changes affecting investment decisions in a white paper must be reported to authorities after white paper approval. Marketing communication should not be misleading and align with white paper content. They must also be available to authorities upon request. The published white paper should also be accessible on the issuer's website, ensuring public availability during the asset reference token circulation and in advance of its public offering. More details will be provided as we delve deeply into the topic of white paper, so I will just leave it that way. One of the main usage areas of real-world asset tokens is actually akin to derivative instruments of capital markets. If a tokenized real-world asset falls into the category of any type of security, then these tokenized assets, as well as the offering and trading of them, will be most probably subject to securities law of relevant jurisdiction. And these rules and principles most probably will be strict and hard to follow. They will foresee requirements almost making it impossible to develop a real-world asset token. Now I will move on to the next topic. Yes, thank you, Sabrin. Legal frameworks for decentralized organizations. To be precise, decentralized autonomous organizations stands for The DAOs are sort of organizations or entities based on smart contracts written on the blockchain. These smart contracts are made according to DAO's purpose, functioning, distribution, and structure. Main difference between the classic organization and DAO is the fact that DAO's governance relies mostly on its codes and smart contracts instead of a typical leadership that we see in corporations or even in partnerships. Thanks to the wonders of blockchain and tokenization, DAOs now can function without the necessity to have a governing centralized body. Governance and other aspects of a DAO can be distributed more easily. Second feature of DAO is being autonomous. Even though DAOs don't have a governing body, they have to be able to operate somehow and function. The governing principle and functions of the DAOs are generally imprinted on the smart contracts. With the development of smart contracts, the decisions taken by the DAOs can be executed autonomously with the minimum human intervention. Also, we will also talk about smart contracts in detail, so I will not explain what smart contracts and what their legal qualifications are. Moving on, what about legal structures for DAOs? Are they regulated? If they are, how? Because of its structure, a DAO can be seen as a partnership in many jurisdictions. Speaking for Turkey and many jurisdictions, if not legally acknowledged in another legal structure, we can basically say that a DAO is basically a partnership, as long as you form that for organization for profit. In general terms, partnership is a relationship established between persons who agree to share the profits and loss of a business, which these persons came together to carry it out. Firstly, if a person or entity acquired or was granted tokens in the DAO, for instance, through an airdrop or as a payment for supplying goods or services to the DAO, that person or entity may become a partner. If no other applicable legislation is present, then organizations that aim to profit are generally considered as partnerships, tokens that grant their holders the power to govern the DAO to some extent, make their holders able to be considered as partners. With being considered as a partner comes a great amount of power and the responsibility. Each partner has the power to bind other partners and the partnership itself. Each partner is responsible for and entitled to debts and obligations of the partnership, as well as its profits and rights. The much liability may result in the liquidation of the personal assets of a partner. Finally, the way that partners define themselves in such relations doesn't affect the eligibility of DAO to be considered as a partnership. If you are seeking a non-profit organization, becoming an unincorporated association might suit you in this journey. Similar to partnerships, if certain conditions are met, members of an unincorporated association may be held liable for the debts and obligations of the unincorporated association. Furthermore, due to the fact that unincorporated associations lack legal entities, legal affairs may be challenging. Limited partnerships and limited liability partnerships are types of organizations that are recognized by most of the governments. Contrary to the classic partnership, at least one of the partners of a limited partnership has a limited liability. In limited liability partnerships, liability of all partners is limited. Because they are meant to address the shortcomings of general partnerships, such as the absence of legal body and lack of restricted responsibility for partners, limited partnerships and limited liability partnerships may be appropriate for profits DAO. Since LLPs and LPs provide a limitation on the liability of its partners, they appear as an eligible candidate to address the shortcomings of partnerships. Additionally, the fact that they are that they constitute a separate legal entity enables these partnerships to conduct legal affairs such as owning property and signing contracts. What about LLCs, limited liability corporations? Some DAOs have been registered as limited liability corporations in the United States. LLCs are controlled at the state level rather than the federal level, so law may differ by state in the United States. But since LLCs are regulated differently by each state, there is no uniform set of rules regarding DAOs. However, regulations set forth by different states don't significantly differ from one to another. Also, LLCs provide a substantial amount of limitation on the liability of DAOs members. On the other hand, they are subject to a wholly regulated structure which limits the flexibility of DAOs. Additionally, due to their profiting nature, LLCs are not an applicable legal structure for non-profit DAOs. Despite its downsides, LLCs appear as the most appropriate legal structure for for-profit DAOs. Wyoming, being the first state in the United States to recognize DAOs, allows DAOs to be established as a LLC. Therefore, relevant rules and principles regarding LLCs will be applicable to DAOs that are established as LLCs. According to the regulation, DAOs shall be recognized as a company. DAOs can own real-world assets. The rights of stakeholders and the functioning of the DAO shall be legally protected by contracts. DAOs shall carry out legal transactions between each other, employ workers, and have an account in a bank. According to Wyoming laws, DAOs don't have to disclose their smart contracts, which is good. However, the same law requires DAOs to have an editable smart contract, which to some extent is contrary to the philosophy of blockchain-based smart contracts. Vermont, on the other hand, another US state, passed an act that allows a DAO to enter into legally binding contracts and protects its owners, managers, and blockchain members from unwarranted liability. As a result, general LLC provisions will apply to such DAOs. Tennessee followed Wyoming's lead and enacted its own DAO law. The entity type in Tennessee legislation, on the other hand, is referred to as decentralized organization. LLCs are, decentralized autonomous organization (LLCs) are subject to Tennessee's ordinary LLC legislation as well. So there is no difference basically. In many ways, Tennessee's law is extremely similar to the Wyoming law. In Turkish corporate law, companies are strictly regulated. Only the types of organization that are foreseen and regulated under Turkish law can be established in Turkey. Their establishment, governance, rights, and obligations of its partners and shareholders are decided by the law. It's strictly regulated. Due to the lack of legislation, DAOs are not seen as a company under Turkish law. The Turkish law system accepts partnerships that do not fall into the scope of regulated ones as an ordinary partnership. Since DAOs can't be regarded as regulated partnerships or corporations, rules and principles regarding ordinary partnerships will be most probably applied to DAOs. For ordinary partnerships, there is no written form requirement. Even the actions of people can be regarded as the formation of an ordinary partnership. Lack of written form requirement increases the possibility of DAOs being accepted as ordinary partnerships. In ordinary partnerships, there is no limitation on the number of partners possible. So there can be unlimited partners. There is no limitation in this regard. Since DAOs tend to have many members, ordinary partnerships are flexible and applicable in this manner. Also, partners of ordinary partnerships are obligated to provide a capital which can be anything that has an economic value. In the context of DAOs, tokens or assets that give out partnership rights have the strong possibility to result in the acceptance of holders as a payment. Also, we have prepared a set of questions that you should ask yourself. If you are unsure whether or not you shall seek a legal entity for your DAO, here are some fundamental questions that you should ask yourself. First one, as a DAO, do you wish to enter into legal relations with other natural persons or legal entities? Do you want your DAO or yourself as a side of a possible legal relation? As a member of a DAO, do you want to create a separate legal entity for your DAO that enables its members to have a limited liability? Or do you want the risky possibility of being considered as a partnership and therefore personal liable of the debts and obligations of the DAO? This is the crucial question. If you want to avoid liability, responsibility as much as possible, being partnership doesn't help you. You shall seek a legal entity such as LLC or something else. Do you want your DAO to own property or to have a bank account? Do you want your DAO to be eligible to pursue its rights before courts? Are you ready to afford, to undertake, and to provide the legal and administrative infrastructure for concluding the bureaucratic, monetary, and legal procedures of establishing a legal entity? To what extent the legal obligations, procedures, and liabilities comply with the way your DAO wishes to operate? These are essential. That's it for DAOs. Now I will talk about taxation of crypto assets in general. When crypto assets are used for transactions, a taxable event may occur, and the taxation of crypto assets depends on how they are held and utilized. Please note that following analysis of events, statements, their definitions, and whether they can be taxable can significantly change according to the tax regulations of any relevant jurisdiction and their understanding of such events. If a person sells or trades crypto assets and makes a profit or loss, it's considered a capital gain or loss. This means that they may be required to pay taxes on the gain, similar to how investors are taxed on gains from other capital assets. Just like with stocks and other investments, if a person sells their crypto assets for a profit, they may be subject to capital gains tax. On the other hand, if someone consistently and intentionally creates and sells NFTs for profit, it can be considered as a business or a professional activity. In some cases, this can give the original creator similar rights to a copyright holder, and any income earned from this activity may be classified as an intellectual property income. Depending on the country, such income may be exempt from taxes if certain conditions are met. One of the greatest problems with taxation of crypto assets is double taxation. Double taxation occurs when the same income or asset is taxed in multiple jurisdictions. This can lead to excessive burdens on taxpayers. Imagine that you are paying twice for the income you generated. It will be unthinkable, unbearable for taxpayers, also unfair. To mitigate this, jurisdictions often have laws or treaties to prevent double taxation. For crypto assets, which are global and decentralized generally, double taxation can be more complex, especially with cross-border transactions. Tax credits, exemptions, or deductions can help, but specifics vary by jurisdiction. Detailed record keeping of transactions and mining activities is crucial for compliance, especially when crypto assets are involved in international transactions or minings. In Turkey, as like many other countries, taxation is strictly legislated and includes income tax, expenditure taxes, and sometimes wealth taxes. Residents or certain Turkish citizens abroad are full taxpayers, while non-residents are limited taxpayers, taxed only on Turkish income. For crypto assets, their legal and tax status is unclear. Though defined in payment regulations, they are not directly addressed in the income tax law, but likely fall under commercial income. The country, the Turkey, is still determining how to classify and tax crypto assets with a focus on applicable income taxes. In the US, moving to US, the International Revenue Service, IRS, treats virtual currency, including crypto assets, as property, subjecting it to property transaction tax rules. This includes convertible virtual currencies like Bitcoin, not considered foreign currency due to lack of legal tender status. The IRS and FinCEN confirm their legality in the US crypto asset trades are seen as barter but exempt from sales tax. Taxation depends on whether the virtual currency is a capital asset for the taxpayer. Mining income is also taxable, and profits from selling crypto assets are taxed as capital gains, with specific rules for assets held over 1 year. So even the time that the amount of time you keep the crypto assets strictly changes the tax implications. So record keeping and reporting of all transactions are actually essential to avoid any penalties. On the other hand, the United Kingdom did not initially have any specific regulations for crypto assets, and instead it relied on existing laws. The Bank of England also did not provide any official statements about virtual currencies for a while. However, the taxation of crypto assets was one of the first topics addressed and has been continuously developed by His Majesty's Revenue and Customs, basically IRS version of UK. For tax purposes, crypto assets are considered unique and cannot be compared to other forms of investments or payments. For example, taxation of Bitcoin transactions in the United Kingdom depends on the activities and parties involved, with potential tax including corporate tax, income tax, and capital gain tax. His Majesty's Revenue and Customs recognize that some transactions may be so speculative that they are not taxable. The tax treatment of crypto assets has become more refined, with capital gains tax applying to gains and losses and similar exemptions as other types of assets. The government does not consider crypto assets to be money for tax purposes. The governor of the Bank of England acknowledges that crypto assets can only act as money for some people and to a limited extent. United Kingdom taxation instructions for crypto assets focus on individuals and their income tax applications. Companies holding crypto assets are subject to corporate income tax rules. His Majesty's Revenue and Customs takes a practical approach to evolving technology of crypto assets and bases its tax treatment on facts rather than the terminology. So it basically asks, what happened here? Is this event can be considered as a taxable event? His Majesty's Revenue and Customs considers crypto asset as a personal investment and charges capital gains tax when they are disposed of. The concept of disposal includes selling, exchanging, using for payments, or even donating. And that's it from us. Now I will let my colleagues take over. Thank you for
Thank you,
listening.
Batuhan. Let's move on with crowdfunding. I have 5 topics to talk about today. I will try to keep it brief and just tell you about the key points of the papers we did before. So let's start. Crowdfunding. Entrepreneurs often lack sufficient capital to bring their ideas to life. Crowdfunding is a legally recognized and regulated process. It offers a vital platform for these individuals to gather the necessary financial resources. So crowdfunding allows people with minimal capital to collectively raise substantial funds. ICOs have emerged as a contemporary method in this domain, utilizing crypto assets and technological advancements. So their popularity stems from factors like convenience, cost-effectiveness, and an alternative to traditional financial systems, especially in times of economic uncertainty. So there are four primary crowdfunding models. One is donation-based, reward-based, the third one is equity-based, and the last one is debt-based. So each model varies in the nature of returns to investors and the legal relationship between fund providers and recipients. In Turkey, for example, crowdfunding is stringently regulated under capital markets law. Platforms must be licensed, and unauthorized crowdfunding activities can lead to significant legal and criminal consequences. ICOs represent a novel fundraising method through blockchain technology. They offer benefits such as global reach and reduced need for intermediaries. However, they also bring risks such as market manipulation and challenges in regulatory compliance. Different regions, including, for example, let's say United States, European Union, China, and Singapore, they have distinct approach to regulating crowdfunding and ICOs. These regulations focus on protecting investors and ensuring market integrity while accommodating technical innovations. Crypto assets in ICOs can be currency tokens, utility tokens, or security tokens. They are each with unique legal implications. The classification impacts how these offerings are regulated, especially concerning securities law. Crowdfunding and ICOs also play a pivotal role in modern finance, democratizing access to capital and adapting to evolving legal and technical landscapes. They open new avenues for investments and entrepreneurial ventures with the need for careful regulatory navigation. We can move on with the next slide. Okay, so introduced by Stuart Haber and Scott Stornetta in 1991, blockchain is a digital and decentralized ledger system consisting of blocks that store transaction data. So the secure, transparent, and immutable ledger system is maintained across a network of nodes, making it resistant to hacking. Let's talk about some advantages of blockchain. There is security and reliability. So without a central database, blockchain minimizes hacking risks. Transparency. It's accessible to all network participants. It ensures transparent transaction and recording. Traceability and accountability. All transactions are recorded, enabling easy verification and authenticity. And lastly, efficiency. Blockchain's non-manual, so self-operating system allows for instant, efficient transactions. There are three main types of blockchain. Public blockchains, they are open and anonymous, like, for example, Bitcoin and Ethereum. Let's talk about consortium federated blockchains. It is a collaboration of multiple organizations. And lastly, private blockchain. It provides restricted access with centralized control. So how does it intersect with IP? So IP encompasses intangible creations like inventions and artistic works. The protection of IP through intellectual property rights includes patents, copyrights, and trademarks, etc. Blockchain can clarify copyright ownership and enable fair market establishment for digital property. IP rights have evolved with technology, so playing a key role in a social and economic development. These rights encourage innovation and protect creators' contributions as well. The blockchain can enhance IP rights management through technology-based registries, enabling easy IP ownership storage or, for example, royalty collection. So it simplifies IP application processes and assists in combating online piracy. The blockchain technology also simplifies IP registration, licensing, and record maintenance. It ensures accurate IP data tracking, thereby it improves efficiency and reducing the risks that it can have. Blockchain streamlines the IP registration process and manages IP contracts effectively. So it can automate licensing agreements and royalty collections without any third parties to be involved. Blockchain also supports IP rights enforcement by providing a secure ledger for authenticity verification, thereby it combats with convertering and IP infringement as well. So let's talk about blockchain and specific IP categories. We have 4 categories: trademarks, patents, trade secrets, and software. So trademarks are simply blockchain. For trademarks, blockchain can simplify trademark registration and evidence of use. For patents, blockchain enhances patent application and examination processes. For trademarks, blockchain secures trade secrets by providing confidential information storage, and blockchain-related software is also protected by copyright laws. There's another topic that we should talk about is NFTs, because they are simply related to blockchain and IP itself. So NFTs represent unique cryptographic assets. So they're distinct from their associated digital asset and do not automatically grant intellectual property rights to its purchasers. NFT transactions involve licensing and copyright considerations, and NFT creators can receive royalties through smart contracts. We will also talk about smart contracts, and please, we have a paper on NFT. I will also talk about it, but please feel free to check it out. So let's briefly talk about NFT ownership and licensing and monetization. Ownership is like NFT ownership does not equate to IP rights ownership of the linked digital asset. NFT licensing terms must be explicitly stated in smart contracts or agreements. And NFTs enable creators to monetize their work, particularly through resale royalties. Okay, we can stay at the same page. Okay, I will continue to talk about legal status of Littlefish Foundation and Action NFTs. NFTs are unique digital assets on the blockchain, as I mentioned, acting as a certificate of ownership for digital or physical assets. They are non-interchangeable, giving them value in establishing ownership of digital creations, and can be traded on digital platforms. NFTs are indivisible and non-interchangeable, representing ownership of assets like art, music, videos, and, for example, real estate. So built on decentralized blockchains, NFTs are secure and they are very much immutable. Ethereum is a popular blockchain for NFTs. NFTs are used in art, collectibles, as I mentioned, gaming, utility, and payment context, offering benefits like authenticity verification, royalty systems, and customized digital currencies. There are no specific laws for NFTs yet, but general laws like intellectual property, consumer contract, tax, securities, and anti-money laundering laws probably will apply. So buying an NFT doesn't automatically grant copyright of the underlying asset. So NFTs record ownership, but separate rights are needed for reproduction and distribution. For example, in the States, USA, NFTs can be subject to various laws, including intellectual property and tax. The Hui test, as Batuhan mentioned earlier, determines if an NFT is a security or not. In the European Union, MiCA regulation excludes NFTs, but GDPR and AML directives will apply. We will also talk about AML today, so there will be further information there. Copyright laws vary across member states. In Turkey, there is no specific NFT legislation for now, but general laws apply, especially concerning copyright. Let's talk about metadata in NFT transactions. So metadata provides crucial information about the NFT and its digital asset. Yeah, please stay on the, yeah. It involves legal aspects such as intellectual property agreements, data privacy, and liability. So in manners of digital notary, NFTs can verify authenticity and ownership, but they lack the full range of legal functions that notaries provide, such as drafting legal documents and verifying transaction legality. Littlefish Foundation's Action NFTs offer a new business model, facilitating transactions in their ecosystem. The sale and purchase of these NFTs involve considerations of intellectual property, tax implications, and sale methods. So they can be used similarly to platforms like Patreon, with tax implications varying based on jurisdiction. We can continue with the next slide. Sabrin. Thank you. The internet and data science have led to the creation of the metaverse. It's a virtual universe behind the physical world. So legal debates arise around the metaverse, especially regarding its social and philosophical implications. The metaverse is originated in Neil Stephenson's novel Snow Crash. It is a virtual environment combining physical and digital realities influenced by advancements in the internet, computer science, and augmented reality. The metaverse will likely face legal challenges similar to the internet, especially concerning privacy and data protection. Jurisdictions may adopt regulations for industries like marketing, healthcare, and finance within the metaverse. So intellectual property rights and ownership issues in virtual and augmented reality will be very significant legal considerations too. Let's talk about property rights in metaverse. So concepts like domain names and virtual assets, for example, digital objects, virtual land, are familiar yet legally very controversial. So reinterpretation of property law is very necessary for the metaverse. NFTs, crypto assets, and AI technologies in the metaverse are currently unregulated on a global scale, I can say. So interaction in the metaverse raises some legal and economic conflicts. Platform neutrality and net neutrality in metaverse platforms may bring legal conflicts to the fore. So unlawful acts in the metaverse, like it is in the internet, can be and probably will be subject to legal sanctions. A mix of traditional legal structures, smart contracts, and blockchain-based systems is necessary for effective contract enforcement in the metaverse. Decentralized dispute resolution methods and community governance will be crucial as well. So the metaverse's reliance on data processing makes data protection very, very crucial. Platforms must ensure the security and confidentiality of their user data. So challenges include protecting trade secrets and managing data collection securely. Users in metaverse are both consumers and producers of content. So intellectual products in the metaverse should be subject to copyright protection. Conflicts over ownership between users and metaverse platforms are to be said likely. The metaverse requires a blend of traditional legal principles and new approaches. So various countries are adopting unique legal frameworks for the metaverse. Examples include Turkey, United States, European Union, Dubai, Colombia, and etc. The rise of cybercrimes in the metaverse is a main concern. So issues of digital dictatorship, privacy, and user rights need addressing, and legal professionals must adapt to handle metaverse-specific challenges in the future. We can continue with the next presentation. Let's talk about a legal status and taxation of earning through Project Catalyst. So crypto assets as a promising technology challenge the traditional financial system with their unique features. Lacking comprehensive regulation, they are often seen as a Wild West, raising concerns about money laundering, tourism financing, and I would say tax evasion. So states either integrate crypto assets into existing laws or develop new legislation specific to them. In some cases, however, there is neither. So leading to a misconception of lawlessness. Taxation is a critical issue due to the economic impact of crypto assets. The legal classification of crypto assets varies. Money, securities, commodities, etc., influencing tax consequences. The different jurisdictions have varying approaches, making it important for taxpayers to understand their local laws. Let's talk about a bit earning methods in Project Catalyst. So earning through Project Catalyst can come from creating proposals, assessing proposals, or perhaps participating in voting. So to summarize, these earnings are likely considered self-employment income, depending on the relationship between the parties that are involved. So let's have a look at different jurisdictions for crypto asset taxation and earning through Project Catalyst. Let's talk about Turkish law, for example. Earnings through Project Catalyst can be viewed as self-employment income. And if so, taxpayers must issue an annual income tax form and adhere to specific tax rates. For US, IRS categorizes virtual and cryptocurrencies as property. So all transactions involving crypto assets may lead to tax consequences, with the calculation based on fair market value in US dollars. For the European Union, taxation varies across member states. There is no uniform European Union-wide law yet. So the approach to crypto assets is evolving, with the European Union focusing on fair and transparent taxation. However, we should note that the tax laws of such state or each state will probably apply locally. Australian law, they treat crypto assets as capital gains or business income, depending on their use and nature. So one must see the law and look for whether it's a capital gain or a business income. For Canadian law, we use earning from crypto assets as either business income or capital gains, similar to Australian, based on the nature of the transaction. UK is tax treatment depends on the use and nature of the crypto assets, similar to other general assets. In Germany, they view crypto assets as private assets with short-term gains, subject to individual income tax. In Belgium, they treat crypto assets income as miscellaneous income. There is, if I'm not wrong, 33% of tax on capital gains from crypto assets. So yeah, that's for the nature of Belgian law. I think it's 33. Okay. As mentioned above, earnings from earnings from Project Catalyst likely fall under self-employment income, requiring attention to tax obligations in the respective jurisdiction. The tax law violations can lead to a fine and penalties. Accurate reporting and compliance with local tax regulations are very crucial. While there is no specific regulation for every new technology, general legal norms often apply. Taxpayers should seek relevant legislation in their jurisdiction to understand their tax liabilities with crypto assets, as Batuhan mentioned before. So that's it from me, and I will leave it to Sabrin. Thank you.
Hello, everyone. I'm going to be talking about white papers, smart contracts.
Sabrin, your voice is not clear for me. It's a bit.
Can you hear me right now?
Is it me only?
No,
I cannot also hear.
You cannot also hear?
Yeah.
I can, but
It's
like
very low.
she's speaking from a distant place.
Yes.
I tried connecting to earphones, but it didn't work.
Maybe, probably. Your earphones didn't work?
Yeah, no. You guys cannot hear me at all, or is it? Should I like?
It's a better now, I think, a little bit.
All right, I'll talk louder if that's better.
Okay.
Okay. All right, I'll get straight into it. White papers are informational documents used for sales and marketing purposes to educate potential customers about a product, service, or technology. They are often used in B2B, business-to-business marketing relationships to inform manufacturers, wholesalers, and retailers. In 2008, Bitcoin was created as a decentralized digital currency that allows direct transactions without government involvement. The white paper for Bitcoin proposed a way to validate and order transactions without relying on a central authority. In the crypto asset industry, white papers serve the same purpose, providing detailed information for potential investors, miners, and users. Some companies have launched initial coin offerings based solely on a white paper or a few lines of code. Now, while this raises concerns for governments regarding tax and banking laws, research has shown that illegal activity on public blockchains has been minimal. Ultimately, white papers can vary in types and formats, focusing on problem solving, informing and debating on an issue, technical assessments, product promotions, or market research. Now, how is crypto asset white papers distinct from other project documentation? In the crypto asset world, white papers provide essential information about projects, aiding potential investors in evaluating investment viability. These papers, typically written in simple language, cover the technical, the economic, and philosophical aspects of blockchain innovations, with an aim to persuade investors, developers, and customers. While similar to traditional white papers, crypto white papers differ in their focus and audience, playing a critical role in fundraising and establishing trust between developers and investors. This contrasts with traditional white papers, which are more often geared towards policymakers and business collaborations and are not usually used for fundraising. But why do white papers matter? A crypto assets white paper is vital for its legal evaluation, as it helps governments determine the asset's legal status. Errors in the white paper can lead to legal issues and project setbacks, especially if these issues violate local laws. An example would be using crypto in payments, where using crypto in payments is banned. Crypto service providers review white papers for compliance before listing a crypto asset to essentially avoid legal risks. Therefore, consulting legal experts when creating a white paper is crucial for a project's success, and adherence to regulations such as MiCA, for example, can be essential for the success of the business or the crypto asset service provider. Risk appraisal is also an important aspect to consider in white papers. Every white paper needs a disclaimer to shield the author from legal claims, stating that the company and team are not liable for any losses or inaccuracies in the paper. For crypto assets, it should clarify that it is not financial, legal, or tax advice and hasn't been government reviewed. This can really make or break a white paper. It's crucial to classify the crypto asset type, considering the legal restrictions in some jurisdictions. The paper should detail the crypto asset's nature and caution its use in regions where it's banned. Additionally, a risk appraisal is essential, outlining potential regulatory and security risks. Market volatility and other factors like technology and operational risks should also be considered. What is the role of a white paper in a crypto asset launch? The white paper is very important when launching a crypto asset because it provides information about the project, the technology behind it, the benefits to potential investors, developers, or community members. It serves as a tool for educating people about the project's goal and vision, as well as being transparent about its objectives, team, and roadmap. The white paper also includes technical details and information about the token distribution and incentives for miners and stakeholders. It also addresses potential risks from various perspectives. Additionally, the white paper is used as a marketing tool to attract investors and engage with the community. A well-organized and legally reviewed white paper is, as I mentioned, very crucial in the project launch. I think Batuhan and Asena also spoke about MiCA, so I'll talk about it briefly here. The Markets in Crypto Assets Regulation is a key EU legislation governing crypto assets and their white papers. MiCA differentiates between types of crypto assets like utility tokens, asset reference tokens, and e-money tokens. It requires that before offering any crypto assets to the public, a white paper must be published, notifying and adhering to specific MiCA articles. In particular, Article 4 states that offers of utility tokens for services or goods not yet operational should not exceed 12 months from the white paper's publication. MiCA is significant as the EU's regulatory practices often influence other countries' legal frameworks in emerging tech sectors. An example of this would be the GDPR. I mean, after the GDPR was released, many countries followed with privacy protection regulations. So, according to Article 6 of MiCA, a crypto asset white paper must contain information on the following. The one offering or seeking admission to trading, the issuer if the issuer is a different person, the operator of the trading platform for the crypto asset in cases where it draws up the white paper, and etc. You can look at our paper on white papers for more detailed information. What are the consequences of misrepresentations in white papers? White papers in crypto assets must be carefully crafted to avoid pitfalls and red flags. A key aspect is including sufficient technical details about the project's technology, consensus mechanism, cryptography, and tokenomics. Simplifying complex concepts is important, but also oversimplification can come out as a red flag. The transparency about the project's teams, identities, and backgrounds can also build trust in communities. And a lack of this, along with any plagiarized content, for example, would raise concern. Also, unrealistic promises or claims of revolutionary technology without adequate explanation could also be seen as a red flag. Tokenomics should be transparent, especially regarding token distribution among team members and individuals. The white paper must clarify the token's utility and project's roadmap, providing a clear value proposition. Adequate risk disclosure and legal compliance information are essential for legitimacy. Misrepresentation in white papers can lead to legal actions, loss of investor trust, negative market reactions, and potentially the project's failure entirely. Accurate, transparent information complying with laws and regulation is crucial to avoid these consequences. So yeah, that's it for white paper. I'll move on to smart contracts. Before we get into smart contracts, how are traditional contracts formed? Upon formation of a contract, both parties typically have certain responsibilities. These responsibilities can be mutually agreed upon or undertaken by only one party. In general, contracts do not have specific form requirements unless stated otherwise in legislation. Contracts can be written or can be conducted orally. However, for certain matters, specific forms may be required, and failure to comply with the required form can render the contract void in its entirety. For example, in Turkish law, some contracts must be in written form and signed by authorized public personnel such as notaries or judges. And failure to meet the written requirements will result in the contract being considered invalid. And moving on, what are the general attributes and characteristics of smart contracts? Smart contracts which were first conceptualized by Nick Szabo in 1994, are self-executing digital contracts with terms embedded in code on digital platforms. And the definition actually varies globally. Italy in 2019 viewed smart contracts as computer programs on distributed ledgers with automatic execution binding parties. In the US, Arizona defines them as event-driven programs on a distributed ledger, capable of transferring assets, while Illinois simplifies it to electronic contracts verified by blockchain. In Turkey, there hasn't been any definition made through a legislation as of yet. Characteristically, smart contracts on blockchain infrastructure like Cardano are immutable, decentralized, and facilitate peer-to-peer interactions without intermediaries. Their code-based nature ensures transparency and security in transactions, reducing costs and the need for trust or the need for third-party oversight. Enabled by blockchain's distributed ledger technology, DLT, these contracts automatically execute parties' obligations, eliminating the reliance that we have on trust when it comes to traditional contracts. Decentralized smart contracts operate independently on the blockchain, free from single-party control, and governed by the blockchain's consensus rules. Moving on, we can look at the developments in Europe. For example, Belarus was the first country globally to legislate smart contracts, defining them in 2017 in a decree as program codes in a distributed ledger for automated transactions or legal actions. The EU is exploring the legal framework for smart contracts on blockchain, with the 2018 European Blockchain Partnership aiming to leverage blockchain for societal and economic benefits. The European Parliament's Legal Affairs Committee recognizes the growing use of smart contracts, but is concerned about their legal validity and enforceability. The European Commission has been urged by the European Parliament, or rather the Legal Affairs Committee, to create a legal framework, particularly for their cross-border use and formal requirements, and suggest mechanisms to pause smart contracts to protect weaker parties. However, the EU currently lacks specific regulation on smart contracts. Italy in 2018 became one of the first EU countries to legally regulate blockchain and smart contracts, and it sort of led the way in Europe. On the other hand, Russia's amendments to civil code in 2019 recognized the potential of electronically self-executing contracts, enabling the use of smart contracts without manual intervention. In the US, there is no uniform federal regulation on blockchain or smart contracts. Federal agencies like the CFTC and the SEC apply existing laws to smart contracts rather than proposing new regulations. And mind you, this is a major contention point. However, several states have taken their own approaches. For example, in Arizona, it was recognized the legal validity of blockchain and smart contracts in 2017, affirming that smart contracts are legally binding even if they deviate from traditional contract formats. Tennessee passed a law in 2018 also, defining blockchain technology and smart contracts, confirming their legal validity and enforceability. Arkansas and North Dakota followed Arizona's lead in 2019, and they legally recognized blockchain and smart contracts. Finally, Delaware pioneered blockchain adoption by permitting companies to issue and register shares on the blockchain since 2017, and actively implementing blockchain technology for state public records. Moving on, smart contracts, like traditional contracts, require mutual consent with offer and acceptance, and typically involve an exchange of value identifiable from the contract language or code. Clarity and completeness of terms are essential for legal enforceability. In commercial contexts, agreements are presumed to be legally binding, unlike in social or domestic settings. When used on distributed ledger systems, smart contracts must explicitly state their intent for legal enforceability. While contracts generally don't need a specific form, for smart contracts, it's crucial to assess if the terms, especially in code, are considered, quote, in writing. The Law Commission of England and Wales used source code as potentially meeting this criteria, but not necessarily lower level code, implying that smart contract terms must be understandable to humans for legal recognition. There are also risks that come with smart contracts. The Law Commission has identified legal issues and risks related, stating that smart contracts can range from partially automated processes like online shopping to fully automated contracts executed on a distributed ledger system. The degree of automation and the format of smart contracts can impact the likelihood of legal disputes and complexities. Interpreting contracts written primarily in code can be challenging, and mistakes can arise when translating code to natural language, which will lead to confusion and eventually lead to disputes. Modifying code on a distributed ledger is also difficult, which can exasperate legal risks. And then I think Batuhan spoke about this, but the Oracle problem is another concern. As a smart contract's performance relies on information from an external database that may malfunction or provide inaccurate data, it will lead to unexpected outcomes. These issues raise concerns about the reliability and predictability of smart contract execution. Moving on, the legal status of data stored in the blockchain. So, blockchain technology is basically replacing traditional methods of establishing trust by authorities or legal entities and third parties. As aforementioned, blockchain is a decentralized system that uses cryptography to secure a record list that allows for quick and secure information transfer. This technology is being used in various sectors, and therefore data plays a very crucial role in the blockchain. And the protection of data privacy has become increasingly important with these technological advancements. And oftentimes data today is called the new oil due to its rather political and economic significance. A blockchain technology consists of three key elements: block structure, distributed network, and consensus mechanism. Blocks in a blockchain contain transaction records and a block header, with each block linking to its predecessor, starting from the Genesis block. The distributed network disperses transaction records across participants, enhancing security compared to centralized storage. In terms of consensus, blockchain networks require agreement on transaction validity using mechanisms like proof of work or proof of stake. Now, blockchain networks are categorized based on accessibility into two types: public, meaning open, and private, meaning closed networks. Public blockchains are permissionless, allowing anyone to access data and participate in the consensus process, for example, like Bitcoin. Partially permissionless blockchains let everyone view data, but only certain users can add new blocks, as seen in platforms where only specific contributors can add content. Private blockchains, on the other hand, or fully permissioned networks, restrict both data access and participation in the consensus process to select parties, often used by companies for privacy and security, such as in bank EFT transactions. All of us are using them technically. Moving on to talk about the personal data protection law, the KVKK. The protection of personal data begins with the right to privacy, which is one of the most essential rights for individuals. It's often in every democratic constitutional country's constitution. The rights to individuality, the right to privacy, and as technology advances, the recognition of privacy and confidentiality as crucial elements of social values in both individualization and the functioning of democratic societies has necessitated the redefinition of privacy as a fundamental human right. According to the Personal Data Protection Law, personal data refers to any information related to an identifiable individual. This definition specifically applies to individuals and does not include data associated with legal entities, which are not subject to the law's regulations. The GDPR, on the other hand, is a law, the EU's General Data Protection Regulation, is a law that aims to protect personal data and increase awareness about privacy. It requires companies to get consent before collecting data and allows individuals to request the deletion of their data. The law was necessary due to the growing amount of data being collected and people just feeling like they had no control over their digital information. However, there may be conflicts with certain business models and digital structures when implementing the GDPR, especially regarding hardware and software design. The GDPR applies to the processing of personal data by EU-based data controllers or processors, as well as subsidiaries and branches of non-EU companies. So data controllers or processors are the company that processes or controls your data. You sign up to a website, the website owner, the company, is who's processing your data. The right to be forgotten is an important right here. It allows individuals to request the deletion of their personal data if there is no valid reason to keep it. However, the nature of blockchain records conflicts with this right, as they are designed to be unchangeable. The right to be forgotten says, I have the right to delete this information, and blockchain records say, well, this information is unchangeable. Some blockchain developers have created editable blockchains to comply with the GDPR, but this compromises the immutability and trustworthiness of the technology, which is like an important contention here. Blockchain technology records records personal data across all system participants, eliminating reliance on a single center or group. In open and permissionless networks, data nodes can be globally distributed, which would complicate jurisdictional law determination. So basically, which courts will be able to decide on such matter? Regulations like the GDPR and the Personal Data Protection Law, the KVKK, apply directly to relevant scenarios, with the GDPR's wide geographical scope implying widespread enforcement, because it applies to the entirety of the EU, all EU member states. However, the global nature of data controllers and processors in these networks might necessitate adherence to various data protection laws at once. So you would have to adhere to the GDPR. You'd also have to adhere to the KVKK at the same time. And if these laws have differing opinions, then that could be a problem for the data processors. Consequently, multinational companies outside the EU may limit EU residents' access to their services or cease EU operations to avoid GDPR compliance. So the data processor, like the crypto asset service provider, can say, I don't want to deal with the GDPR as well as all these other regulations, so I don't want EU residents to access my services, which kind of makes the whole global aspect of the technology null in a way. So yeah, that's the legal status of data stored in the blockchain. Our last topic, AML and KYC regulations. KYC is Know Your Customer. It's a standard procedure in the financial sector to confirm client identity involving personal data collection and, in some cases, financial evaluations and background checks. KYC guidelines help prevent fraud and money laundering, improving financial market integrity and compliance. Key goals of KYC include preventing illicit financial activities and compliance with legal standards. KYC enhances risk management for financial institutions and protects identity theft and financial fraud. But obviously, there are also challenges with KYC. Increased data collection leads to risks of data breaches and privacy concerns. Technological reliance and cybersecurity risks are significant here, posing challenges for these financial institutions. The complexity of legal compliance and diverse international regulations also add to the challenges. Along with KYC, we have AML, anti-money laundering. AML policies are designed to prevent disguising illegal funds as legitimate and involve transaction monitoring, and record keeping. Global efforts led by organizations like the Financial Action Task Force, the FATF, coordinate AML activities. The blockchain enables decentralized consensus without external authority. It introduces concepts like immutability, decentralization, and trust minimization. The integration of KYC and AML, which often go hand in hand, these regulations with the crypto industry is actually complex, involving legal and technological considerations. There is an ongoing debate about balancing regulations and preserving the crypto sector's unique aspects, as aforementioned. What are the global perspectives on AML and KYC? Different countries, including the US and EU, have varied approaches when it comes to compliance with AML and KYC in the financial and crypto sector. Jurisdictions implement diverse regulations impacting how crypto assets and service providers operate. The European Union has been strengthening its regulations on KYC standards to fight money laundering and terrorist financing. The fifth AML, the Anti-Money Laundering Directive, implemented in January 2020, extended the rules to include virtual currency platforms and wallet providers. It also required more transparency in the ownership of companies and trusts. The EU introduced the sixth anti-money laundering directive in December, which expanded the definition of money laundering offenses and increased the range of criminal activities that were covered in the directive. It also allowed companies to be held responsible for money laundering and imposed harsher punishments. Financial institutions and obligated entities meaning the entities that are obligated to follow the directive, are now required to continually monitor their business connections to identify any suspicious transactions. Excuse me. In the US, the Bank Secrecy Act sets the foundation for AML and KYC laws, compelling financial institutions to aid in identifying and preventing money laundering through reporting significant transactions and suspicious activities. It includes strict KYC protocols for customer identification and record keeping. The Anti-Money Laundering Act within the NDAA broadens the Bank Secrecy Act scope. introducing reforms like increased whistleblower incentives and national AML priorities. Additionally, state-specific regulations also exist, like New York's and California's, further complicating the regulatory environment because they have distinct licensing and compliance requirements. Turkey, last but not least, is dedicated to combating money laundering and aligning with international standards. The primary legislation for this effort is Law Number 5549, which was first established in 2006 and subsequently amended to enhance its efficacy. This law defines the duties of financial institutions, reporting entities, and supervisory bodies. MASAK, Turkey's leading authority in anti-money laundering, is responsible for enforcing regulations, conducting investigations, and coordinating information exchange. Adhering to the FATF recommendations, MASAK has issued directives for crypto asset service providers mandating KYC and AML protocols since May of 2021. These directives categorize obligations into customer identification, reporting suspicious transactions, maintaining and submitting records, and providing continuous information documentation. All in all, because most AML and KYC laws are sort of derived from the FATF, they're very similar to each other. So, yes, that's the AML and KYC regulations. And thank you for listening.
Thank you, Sabrin. If you have any questions, I would like to address them as much as possible. No questions then.
Yeah. Yeah, thank you for participating. And these recordings will be available on YouTube. And have a nice day. See you.
Thank you. See you.